Hi out there, my name is Valkujin once again, and today we are handling hearsay evidence as a concept in evidence 1. So when we say hearsay evidence, this is basically evidence that is made through assertions or assertion of statements made to a witness by a third party. So these statements are given to the witness for purposes of presenting them in court. So the general rule as to hearsay evidence is found under section 59 of our Evidence Act, that is Cap 6, which says that all oral evidence must be direct. That means any other evidence that is not direct is hearsay evidence. And the rule is that hearsay evidence is not admissible before court. And the rationale for this was found in the case of Marshall versus Republic, where it was held that hearsay evidence cannot be admissible before court because it is not subjected to the ordinary tests of the law. For example, cross-examination. Since this person who made the assertion is not around, and therefore we shall not examine them and see whether the statements were really right. And secondly, these people are not, like, their conduct is not examined to see whether what they are saying, whether they are very sure about what they are saying. And thirdly, they are not making these statements before the penal sanctions of oath. And those are the reasons why we say that hearsay evidence is not admissible before court. However, we all know that every general rule there are exceptions, or there will always be an exception. So for the exceptions as to the hearsay evidence are found under section 30 of Evidence Act Cap 6. So we shall read together the Evidence Act section 30, which says, section 30 of the Evidence Act says that the short title reads that cases in which statement of relevant fact by a person who is dead or cannot be found, etc., is relevant. In other words, there are instances where the evidence of the person who is not around will be considered admissible. That is the hearsay evidence. And these are as follows. Number one, we have dying declarations. When the person who made the assertion is dead, such an assertion may be admissible as evidence before court. And under the dying declaration, it is under section 30, subsection 1 of the Evidence Act Cap 6. And here they say that such evidence must be treated with a lot of caution, because it is not the person who made the statements or the assertions is not subjected to cross-examination, because the person is already dead and the person is not around. That was stated in the case of Sabiti Vincent versus Uganda, where it was said that such evidence must be treated with a lot of caution. So what are the elements of hearsay evidence? The elements are as follows. The person who made the assertion must be dead, because we've said it is dying declaration. The person who made declaration must have died. That is number one. And then the statement must be free expression of the person who made the declaration. And thirdly, the assertion or the statement must be corroborated. Here I mean that there must be something else that backs up the declaration. For example, if the person died maybe after saying so and so assaulted me, maybe on the stomach. Let's say maybe when we try to get a medical report, the medical report says the person died as a result of injuries maybe in the stomach. So the medical report will have collaborated with the dying declaration. So that's what we mean by saying it has to be collaborated. And then the statement must be complete. We cannot say it is dying declaration when the person was still making the statement and died. That one will not be considered as dying declaration. The statement must have fully been made. Like, it should be complete. Yes. So that is dying declaration as an exception to hearsay evidence. This is evidence of the person of the person who is not around. The person who made the declaration is already dead, but we are considering it as admissible under the exceptions under Section 30 of the Evidence Act. Number 2 is statement made in ordinary business. That is Section 30E of Section 30B of the Evidence Act, which says that when the statement was made by such a person in the ordinary course of business, and in particular when it consists of any entry or memorandum made by him or her in books kept in the ordinary course of business. Yes, so here we are basically looking at an assertion that was made by someone in the course of business. Maybe they were carrying out a certain business and the person made an assertion, and this assertion was maybe put in their books of the business in their books of the ordinary business. So such a statement will be considered as evidence. Much as the person who made the assertion is not around, it will be considered because it was a statement made in the ordinary course of business and was recorded in their books of ordinary, the books where they record their ordinary course of business. Yes, so important to note is that such a statement that was made in the ordinary course of business will only be evidence if it was made before the dispute arose. If the statement was made before the problem or the challenge arose, it will be considered as evidence, not a statement that is made by someone after a conflict or a dispute arising. It must be advice. Yes. We shall proceed to the third. Remember, we are reading Section 30 of our Evidence Act. So, when you read C of Section 30, it will say that when the statement is against the pecuniary or proprietary interest of the person making it. Here we are looking at a statement which is made by someone, and that someone made a statement that is against them. It will be considered as evidence. Yes, and here what we will illustrate it very well for us is the case of R versus O'Brien. In R versus O'Brien, these were two individuals, O'Brien and Jensen. So these were convicted of having possession of narcotics. So O'Brien surrendered himself and he was convicted, but Jensen fled out of the country. So as O'Brien was convicted, Jensen got information and he returned back to the country. So when he returned, he made statements that he was the sole perpetrator of the crime, and he died there. He died then. So O'Brien tried to come before court and ask for review of his conviction. However, it was declined on ground that the statement was made because his colleague or counterpart wanted his friend to be released, and therefore he was not set free. That's what I was trying to explain when I said that the statement must have made prior. Yes, the statement must have been before the conflict arose or the dispute. Yes. So the fourth, that is D of Section 30 of the Evidence Act, Cap 6, which says that when the statement gives the opinion of any such person as to the existence of any public right or custom. Yes, so when a statement is made and the statement is having an aspect of a public right or interest, it will be considered as evidence. But still here, the statement must have been before the dispute arises. When the statement is made after the dispute has arose, then that one will not be considered as an exception under Section 30 of our Evidence Act. Yes, please find time and read through these provisions of Section 30 of the Evidence Act, because that's where we are finding the exceptions as the hearsay evidence, as the general rule is under Section 59 of the Evidence Act. Yes, so E is saying that is in relation to relationships. It reads that when the statement relates to the existence of any relationship by blood, marriage, or adoption, between persons as to whose relationship by blood, marriage, or adoption the person making the statement has special means of knowledge, and when the statement was made before the question in dispute raised. Yes, so here we are looking at situations where a statement is made in relation to relationships. Maybe it is a marriage relationship, maybe it is relationship by blood, maybe someone made an assertion that so and so is our brother. Yes, so when such a statement was made prior to the dispute arising, it will be considered as evidence, much as the person who made the statement might not be around at that particular moment. But as long as the statement was made prior, and the statement is in relation to a relationship, maybe by marriage or adoption or by blood, it will be considered as evidence. And the rationale behind this is that the person who made the statement didn't know that the statement would be subjected to the person who made the statement didn't know that such a matter would lead to a litigation. So we may not say that the person was maybe compromised. They made the statement genuinely. Yes. And then F also talks about relationship, and for this one talks about relationship in relation to deeds and wills. For example, when someone made a statement and the statement appears in a will or a deed, it will be considered as evidence, much as the person who made the statement might not be around at that particular moment. But as long as the statement was made and there was an aspect of relationship as to blood, adoption, or things related to that, will be considered as evidence, much as the person who made the assertion is not around. But still, here the assertion must have been brought before a dispute arises. In all these circumstances, as I'm discussing, the assertion must have been made prior to the dispute arising, so that there will be an argument that the person who made the assertion did know that there would be litigation later on, and therefore their statement was made genuinely. Still, paragraph G of section 30 of the Evidence Act, Cap 6, still also talks about the statement that is contained in any deed, will, or other document which relates to any such transaction as mentioned in section 12A of this same act. And then H also talked about where the statement was made by a number of persons and expressed feelings or impressions on their part relevant to the matter in question. When many people made an assertion as to a fact, then it will be considered as evidence, as long as those people may not be around. So, what you need to understand is that hearsay evidence, the general rule is that it will not be admissible. But the exceptions are laid down under section 30 of the Evidence Act, which includes dying declarations, relationships, matters of relationships, maybe as to blood, as to adoption, things like that, and maybe statements made in the ordinary course of the business. Yes, those ones will be considered as admissible before court, much as the person who made the statement might not be around. And the reasoning for considering this evidence is that neglecting such evidence may lead to a crippling justice. So if it appears that admitting such evidence will have to bring evidence, remember our main aim of the law is to bring justice. So when it is realized that if this evidence is brought before court and admissible before court, justice will be realized, then it will be considered, much as the person might not be around. And the reason is that we may find that the person who made the assertion maybe died, or maybe the person is not in position to talk and express the statement they made, or maybe the person is far away, maybe the person is out of the country, such that asking them to come back to the country would be so costly, or maybe it would lead to delay. We shall have to consider the statements they made, but with a lot of caution, since such statements, such people will not be subjected to cross-examination to find whether there is truth in the statements they made. Yeah, so basically that is hearsay evidence. The law you need to rely on, that is section 59 of the Evidence Act, section 30 of the Evidence Act, and a number of cases, as I have mentioned some of them, and you might need to go further and find other cases that might help you understand hearsay evidence. But basically that is it. However, this discussion is not exhaustive. It is just trying to bring light to us about what hearsay evidence is. So I urge each one of us to go and do an extra mile to look for textbooks discussing hearsay evidence, and you'll be relating this discussion to what the textbook will be discussing to you, and then you'll have to understand the concept further. Yes, you should not just say this is a gospel truth. Go further and read about hearsay evidence. Thank you so much for listening. I hope you find this helpful. Please, for any inquiries, you might reach out, and yes, help will be there as it has always been there. Thank you so much for your time.